On the record in the matter, the people of the state of Michigan versus Hughes, file number 24-01879. Council Grant.
Good morning, Your Honor. Case mark hearing on behalf of the people. First, make a motion to practice court number 120.
Motion granted.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Hughes, who is standing to my right.
Okay. Mr. Hughes, you have a final pretrial that was scheduled this morning. Just for one count of domestic violence. The offer that was previously extended was to plead guilty with 769.4A. How are we proceeding?
This time, the necessary witness, Mandy Ritchie, has failed to appear. We have attempted contact at our office about 5 or 6 times by my count. We have not had successful or good contact, so the people are unable to proceed.
Thank you, Your Honor. Given the representations by Mr. Markarian, I would make a motion to dismiss.
Motion to dismiss is granted without prejudice, so the people do have the right to reissue the charge against you, okay? Do you have any questions about that?
No, Your Honor.
Any additional matters for the record, counsel?
Further from the people, thank you.
Nothing further. Thank you.
Have a seat. We'll get you a copy of the dismissal. On the record, in the matter of the people of the state of Michigan versus Michael Daniel Thomas, file number is 23-01315. Appearance.
Good morning, Your Honor. Case mark hearing appearing on behalf of the people.
Jacob Riley on behalf of Mr. Thomas.
Okay, Mr. Thomas, it's date set for final pretrial. It was a police officer assault. There was an offer for you to plead guilty to disorderly jostling with no objection to credit the time served. Also, how does your client want to proceed?
Your Honor, Mr. Thomas is not interested in accepting the offer.
This matter is scheduled to, is it scheduled for trial already?
I do not believe it's currently scheduled for trial.
Scheduled for a jury trial.
Our office will be reissuing was the offer, Your Honor. We'll be reissuing that one as an amended complaint for the felony resisting and obstructing anyway, so I'm not sure.
Oh, okay, that's why we don't have a trial date. Got it. Okay. So your office is going to reissue, so we need to nolly this one and then you reissue?
Yes, Your Honor.
Okay. You have any questions today, sir? Okay, any additional matters for the record?
Further from the people, thank you.
No, Your Honor, thank you.
You can have a seat. We'll get you a copy of the nolly for this particular file. Once they file the new charge, you'll need to be rearranged, okay?
Okay.
On the record in the matter of the people of the state of Michigan versus Jada Otis, file number 24-02219. Council appearance, please.
Good morning, Your Honor. Case mark hearing appearing on behalf of the people.
Oh, okay, sounds good. Okay, you can have a seat, ma'am. They gotta find your attorney. Sorry, just writing that down. All public defenders are out of it. Let's see, on the record of the matter of the people of the state of Michigan versus, is it Zoo? Phone number 24U203871. Council appearance.
Good morning, Your Honor. Case mark hearing appearing on behalf of the people.
Good morning, Your Honor. Yin Fair on behalf of Mr. Yu standing next to me on my right.
Good morning, Your Honor. My name is Yue.
Thank you. Today was the date set for a pretrial. This was for an expired license. Have the parties been able to resolve this, or do we?
Yes, Your Honor. I have seen proof. I'm just waiting for the confirmation to get emailed over, but our office, once we get that, will upload it to our file and dismiss.
You say you've seen proof of the,
Of a valid license and proof of insurance. The ticket that I had for this read that it was no insurance and driving with licenses.
it's only set for expired license.
Okay, I have seen the proof of the valid license. I'm just waiting for the photograph to get emailed over so we can come for it.
You have a copy of his driving record.
I do have one. I'm sending this right now.
wish to approach one?
So it expires next year.
Yes, sir. Your Honor, we've moved to dismiss the charges at this point based on the proof that's been provided.
Motion to dismiss is granted as to this. Let me see what's going on with the plate. Is there a default? Okay.
Yes, it was.
Okay, so you're all set on this. Thank you.
Thank you, Honor.
On the record, in the matter of the people of the state of Michigan versus Michael Drobny, file number 24-02257, council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Raleigh on behalf of Mr. Rodney.
Mr. Drobny, today you have a pre-trial for police officer assault and malicious destruction of property and assault and battery or attempted police officer assault resisted destruction. Was there an offer on this at all?
Yes, Your Honor, there was a couple options extended. The first being to participate in mental health court and to plead under that. I believe it's my understanding Mr. Drobny wants to consider that. We'd like this reset for another week.
That is correct. Your Honor. We would ask for a second pretrial, hopefully at least a month out, so we can go through the screening process for the special court.
Set this 30 days.
October 1st at 8:30.
October 1st at 8:30. Do you have any questions today? We'll get you a copy of your notice to appear. Any additional matters for the record? Counsel?
Nothing further from the people. Thank you.
Thank you.
You're all set. On the record, in the matter of the people of the state of Michigan versus Jada Otis, file number 24-02219, council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Otis, who is standing to my right.
Okay, let's see what's going on here. I see my note from the 15th that there was an added count of assault and battery, and the remaining was knowledge. However, we never received an amended complaint. This was supposed to be set today for a final pre-trial. We have witnesses here.
We do not, Your Honor. No subpoenas went out because it was not put on the docket or noticed. Again, I understand that's because we didn't provide you an amended complaint in a reasonable time, though. I have provided that this morning off the record to the court secretary. I have had good victim contact on that. She planned to show up to everything, so I don't see any reason why we would need to do anything other than keep the jury trial date the way it is.
Well, we can't keep the jury trial if we don't have a complaint.
Yes, Your Honor. Fair enough.
Get a complaint, then we'll keep the trial, but,
I did just send it over this morning
oh, okay. You sent it here.
to court staff, Addie and Yolanda, as well as Mr. Goodrich being CC'd on. But it was moments before you took the bench, Your Honor, so.
You can print it. You can have a seat. I'm going to get it taken care of today.
And Your Honor, if the case is going to move forward, could we get another final pretrial date to see if we do actually have a witness?
Yeah, no problem. I'm gonna sign it.
Calling Mr.
Review it.
Markarian a liar, but sometimes clients lie to him as well, so fair enough.
I-
Defense, I mean,
Absolutely.
but-
I get it. September 17th. Oh, my ears are a little blocked.
September 17th.
September 17th at 8 a.m. for the final pretrial, okay?
Yeah.
It's not Is there another? Try to put the sign stuff. For Thomas. Let me just get Miss Otis her notice. Okay, on the record, in the matter of the people of the state of Michigan versus Robert Edward Hart, file number 23-00356, council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Hart, who's standing to my right.
Mr. Hart, today's date that's set for a pre-trial for count one, child abuse in the 4th degree. How are we proceeding on this?
Your Honor, there has been an offer extended to participate in appellate court, and I believe that Mr. Hart intends to consider it. Potentially disagree, but I'll leave that up to this.
Thank you, Your Honor. That's correct. There was a kind of twofold offer, that as well as an additional one if mental health court is not an option. I have discussed that with Mr. Hart, who would like to consider it. We would ask for a final pre-trial here.
Outside of final pre-trial, I'm not requiring witnesses to appear.
The trial, September 17th.
Final pre-trial will be set for September 17th at 8 o'clock in the morning. You have questions for the court today? Okay, we'll get you your notice to appear. One matters for the record.
Nothing further from the people. Thank you.
You're awesome. On the record, in the matter of the people of the state of Michigan versus Andre Susana, file number 24-02259. Council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Riley on behalf of Mr. Susanna.
This is Andre Susana Jr. Oh, today's the date that's set for a pre-trial. Count one, aggravated domestic violence. Count two, child abuse in the 4th degree. Was there an offer on this at all?
Yes, Your Honor. The offer was to plead to an added count 3 of domestic violence with sobriety court, and then we would dismiss count 22.
Added count 3 with sobriety court, you said?
Correct, Your Honor.
Sobriety court.
I believe it would be 55th, Your Honor.
So he needs to be screened for that.
In order to be clear, my client would be requesting final pre-trial.
Oh.
The trial, September 17th at 8 a.m. Jury trial, October 22nd.
Final pretrials will be September 17th, 8 o'clock in the morning, in person at the court. Jury trial, October 22nd, in person at the court, okay? You have any questions? Any additional matters for the record today, council?
Nothing further from the people. Thank you.
Nothing from the defense, Your Honor. Thank you.
We'll get you your notice to appear and then you'll be all set, okay, sir?
Thank you.
Thank you. Mr. Thomas, were you waiting for paperwork?
The nominee was-
So what? You're good to go, sir. Is Leo Bayer here at all?
That yesterday.
Hmm?
The probation officer said that yesterday. I don't know what the show clause is for, but he thought it was.
Oh, that's what it's for, I think. Yeah, that completely. Okay. Okay, that's done. On the record in the matter of the people of the state of Michigan versus Marcel D'Anthony Carter, file number 24-02285 and 24-02196. Council appearance.
Good morning, Your Honor. Case Mark Carrion appearing on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, representing Mr. Carter, who is standing to my right. Let me correct, on file 24-2196 FY.
And Jacob Raleigh appearing on behalf of Mr. Carter on file 24-02285.
This is the date and the time set for a pretrial on file number ending in 2285. And then we have a PA 53 contempt on the other file. How are we proceeding today?
Your Honor, regarding the pretrial file 24-02285, an offer was extended to Mr. Raleigh on that. Unsure what his client plans to do, but the offer was to plead guilty as charged and avoid any reissuing with child abuse charges based on the evidence that was provided. As for the PA 53 file, Your Honor, 24-02196, I have Officer Jamil Jones here and ready to testify, and I just have a preliminary matter to attest before.
Okay, Mr. Raleigh, how's your client want to proceed on the misdemeanor?
And we'd be requesting a second pretrial conference. There is, as council just noted, a significant amount of new discovery that has been provided, and we'd be able to do that with our client. Make a final decision on that.
September 10 at 10.
September 10th at 10 o'clock. You have any questions on that file, sir? Okay. And how are we proceeding on the bond violation?
Your Honor, oh,
I was just saying, you were planning to run the hearing on that.
Eyewitness.
if I may, Your Honor, just have a preliminary matter to address before I call the witness.
That's-
I would be requesting the court to take judicial notice of an adjudicative fact pursuant to MRE 201B2. The fact that I would be requesting the court to take judicial notice of is the distance between the complaining witnesses, Kylie Bauer's house at 109 Fernhill Court in Lansing, Michigan, and the one-stop shop located at 1245 East Grand River Avenue in Lansing, Michigan, where the defendant was ultimately detained and arrested for the alleged bond violation. Based on a Google Maps search I did, the distance between the two is 187 feet.
So noted.
Thank you, Your Honor. With that, we're ready to call Officer Jones.
You can have a seat, sir. Raleigh, can you turn that fan on, please? Thank you. Probably needs to be the next one. Hit it again. Thank you. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. Please state your first and last name and then spell both.
Jamel Jones, JAMBEL, last name Jones, JONES.
Get the street pencil.
Thank you, Your Honor. Officer Jones, are you currently employed?
Yes,
Where?
at the, for the city of Lansing, police department,
What is your current rank and assignment?
patrol officer,
What do you do in your normal duties as a patrol officer?
patrol streets, so, to serve the community, enforce, laws and ordinance.
Do you or have you, in your experience as a patrol officer, responded to calls of an allegation of a violation of a bond condition?
Yes, sir.
How often? If you can guess.
So far, about 10%.
How long have you been on patrol with the Lansing Police Department?
Since December 11th.
On August 3rd of 2024 at around 12:08 a.m., were you on duty?
Yes, sir.
Did you at some point receive a call to be dispatched to the location of 109 Fernhill Court?
Yes, sir.
What was that call for?
For a domestic.
Objection, hearsay, Your Honor. I'm not sure that I don't believe this is the person who received the call. And I don't know if he directly heard what it was for.
Okay. You want to address the objection?
Yes, Your Honor, I wouldn't be using this to prove the truth of the matter, asserted just the next steps the officer took in light.
Objections overruled.
So what was that call for?
It was involved with assault. It was related to me over the dispatch radio that a female was having a domestic issue with a male, and she took off and took to male followed her to the home store and then left.
Do you recall who that female's name was, or what that female's name was?
Highly.
Do you recall a last name? Would it refresh your memory if I approach you with a copy of your report? Counsel? Permission to approach, Your Honor?
Yes.
Officer Jones, if you could just look at that report for the full name of the caller, and whenever you're done, just look up me when your memory is fresh. Has your memory been refreshed? All right, I'll approach. What was the name of that caller?
Kylie Savannah.
Now,
Said what, Kylie, what?
Kylie Savannah Bauer.
yeah, and we do have some fans going in here now just because of the heat, so you might need to raise your voice up a little
All
extra. Now, we originally discussed the location of 109 Fernhill Court. Do you know what's at that address?
When I find court, that's her residence.
By her, who do you know?
Kylie.
And then you said that there was an update from dispatch at some point. Tell me about that.
Yeah, so we were responding to the address. A new address, or the secondary address was the corner shop, the one-stop shop on Cedar Southwest.
Did you respond to that one-stop shop on Grand River?
I did.
What happened when you responded?
I responded, I walked into the store, the store clerk or the owner had informed us that he hit Kylie and.
Objection, this is hearsay, Your Honor.
Again, Your Honor, wouldn't be using this for the truth of the matter, so Your Honor, just next steps in the officer's investigation.
Objections overruled.
Please continue.
The store clerk had basically escorted us to the back where he hit Kylie in the freezer. When we got back there, opened the freezer, she was standing there holding her baby in her arms, and then we kind of hesitant to come out to talk to us.
At some point, so you stated that the clerk pointed you to a freezer and then you found Miss Bauer inside holding her baby.
That's okay.
At some point, did Miss Bauer identify this person that she was accusing of?
Your Honor, I'm going to make the same objection here that any statements by Ms. Bauer would be hearsay. I understand it may be for use for other purposes, but not for the truth of the matter.
Your Honor, maybe heard.
So you may.
This particular statement would be a statement of prior identification, would fall under the non-hearsay use of that. Even if you're on appeals, it doesn't fall under that. It's just next steps in trying to identify the suspect.
Objections on move.
So at some point, did Ms. Bauer identify this person that she had hid in the freezer from?
Yeah, she said, I believe her.
Do you recall that person's name?
I just looked at the person's, her.
Would it refresh your memory if I approach you with a copy of your report? Commissioner Bergeron,
Yes.
Officer Jones, just look at that report and then look up at me when your memory has been refreshed on the suspect's name. Has your memory been refreshed?
Yeah.
Who is that suspect that was identified?
Marcel D'Anthony Carter.
Did you at some point make contact with a person named Marcel D'Anthony Carter?
Not initially. When we got to the one-stop shop, Hughes was gone. So me and my partner had conducted an investigation, and we were informed shortly after conducting our investigation from the store clerk, that Marcel was returning back to the store, and he saw this on his surveillance camera, the face screen, TV screen. That was above the counter.
Well, let me break that down a little bit. So it sounds like this happened while you were taking a statement or after?
Taking her Kylie statement. Marcel returned back.
And you were, and who advised you that he was
The store
returning back to the store? How did the store clerk know?
Watching his surveillance camera, the TV. So the camera faces the parking lot, and while we were conducting our investigation, we were behind the counter looking up at the TV screen.
Without telling us anything that the clerk said, did he identify this as the suspect you were looking for, this person walking back in? What happened after that person? Well, did they walk into the store, this suspect?
Yes.
What happened after the suspect, Marcel Carter, walked into the store?
So while walking to the store, and we immediately detained him. Me and my partner, he was wearing, I believe, a red shirt, black shorts, and carrying a black bag or like a fanny pack of some sort.
At some point, did you go back to that 109 Fern Hill Court after, well, excuse me, did you make an arrest of this suspect as well?
Yes, shortly after Marcel was detained, we did make an arrest. My partner transported Marcel to our downtown lockup. I completed the rest of my investigation with Kylie. She walked back to her home.
Let me stop you there.
Mhm.
You said Kylie walked back to her home. How close was her home to this location?
Gonna be no more than 100 meters.
100 meters. Do you know what that is in feet? Let me ask it this way, more or less than 2,000 feet?
Less than 2,000. Definitely less than 2,000.
By a lot or by a little? Okay. At some point, did you, now you said you made an arrest of the suspect, Marcel Carter. What was that for?
It was for domestic violence.
Regarding any bond violation or conditions of a bond, did you do any research into those?
I believe my partner did. There was a PA-53 bond that were in place.
Do you recall what the terms of that bond were?
Not molest, beat, intimidate, threaten, protect the party is highly, not be within 2,000 feet radius of the colleague resident.
This suspect that we've talked a lot about, we've name identified as Marcel Carter, the one you arrested. Do you see them in court here today?
Yes.
Could you please identify that person and point them out by an article of clothing they're wearing?
No, blue sweater button up with silver buttons, beard, goatee, fairly decent shape haircut.
Please let the record reflect Officer Jones has identified the defendant, Your Honor.
Any obstructions?
No objection.
No further questions at this time. Thank you.
Cross-examination.
Officer Jones, you were initially dispatched to 109 Fern Hill Court, correct?
Yeah.
Did you ever go to 109 Fern Hill Court?
Did not go to 109 trying to.
And you received a message over dispatch that that was where Miss Bauer lived, or what did you understand?
That was the initial location that we were supposed to respond to, but after we responded, yeah, it turned out that she was at the store.
Okay, so you actually made it to the store, not to 109 Fern.
Correct.
Okay, so you never actually saw Miss Bauer go into that house?
No,
You never saw any of her property at that location?
in the beginning,
Yes, at any point. You
Oh,
never, did you ever see any?
after the arrest, she walked to her home with her baby in her hand. I followed up behind her and showed that she didn't run back.
Okay, so you saw her.
And she,
Did you go into the home at all?
yes, sir.
Now, when you see Mr. Carter approach, did you see the surveillance of him approaching the place, or did you just go outside?
Approaching the store?
The store, yes.
No, I did not go out of the store to approach him. He walked into the store.
You stopped him right about the door, correct?
I would say about within at most 20 feet inside the door.
At that point, Miss Bauer was still in the back of the store, is that correct?
At that point, she was more so like middle of the store to the back of the store.
But she would not have been visible to somebody just walking into the store at that time, right?
Yes, she was visible.
Well, okay, so you saw her did you see them both at the same time? Or
While we was conducting our questioning with her, and this was outside of the freezer and like the main alleyway where the counter is, myself walked in.
okay.
So
and you stopped him right away as soon as you walked in the store, correct? Okay, so he didn't have a time to turn around and leave the store or anything along those lines. You grabbed him immediately.
No, he walked in for the test.
Right. Okay, and that's what I'm saying, but he would not have had time to leave the store after you announced that you were going to stop him.
No, we did announce and told Scott he saw our fully marked uniform and told it.
And he complied with that?
He kind of came off, he didn't know what was going on.
But he did not flee. He did not flee from you, did he?
No, he didn't try to, he didn't resist or anything like that.
And he basically allowed you to stop him and ask questions at that point.
Correct.
And then he was arrested and placed into I take it a squad car at that time?
At that point, he was not arrested.
But you did eventually, I guess, convert the detainment into an arrest at some point?
Yes, sir.
Your Honor, no further questions at this time.
Yes, Your Honor. Officer Jones, you stated on cross-examination that you did go to the house.
Sure.
Based on your training experience as an officer, when you went to that house, did you see or observe any evidence that would corroborate some sort of an assault happened?
Yes, sir.
What was that?
Initially, when I exited my police patrol marked vehicle, there was objects in the yard that I pointed out. One, which was her ring cam that was ripped off. To the door to her home was open. Upon walking even closer to the front door, you can definitely see like there was some type of struggle that occurred. The front living area was shoveled, leading all the way back to the dining room area and to the kitchen, and then also in her bed.
Who was arrested for all of this damage?
Myself.
Thank you. I have no further questions, Your Honor.
I think you could be excused, Officer Jones.
Ma'am.
You could be excused.
Okay.
Any other witnesses?
No, Your Honor. Before us.
Any witnesses from the
The
defense?
defense is not intended on calling any witnesses. Your Honor.
You can proceed to argument.
Yes, Your Honor. We are, as you know, here for a PA 53 bond violation hearing, specifically the allegations of a violation of a no contact order. And looking at the bond that Mr. Carter had for the underlying case, there are 3 conditions in particular. First, to not assault, harass, intimidate, beat, molest, wound, or threaten Kylie Bauer. Second, to not have any or cause a third party to have any direct or indirect contact with Kylie Bauer. Third, to not be within 2,000 feet of where Kylie Bauer works, lives, or goes to school. Your Honor, based on the evidence we heard from Officer Jones, I believe all 3 of those conditions were violated, and we do have a bond violation here. Officer Jones testified that he responded to a domestic assault call, that upon responding to what was originally the victim's home, an update came through dispatch that she was now hiding in a freezer at the One Stop Corner Shop at the end of the road to get away from the defendant. Upon response to there, they were directed to a clerk who directed them to the freezer, found Miss Bauer inside with her baby, who gave a statement identifying Marcel Carter, the defendant, as the one who had just assaulted her and that she was hiding in the freezer from. Then while taking this statement, Marcel Carter quite literally walked into the one-stop shop with Miss Bauer in. I anticipate the argument might be that he had no clue that she was in there, but Your Honor, again, they were literally responding to there because she had to go hide from him after being assaulted at her house. Then the officer went back to her house, observed things thrown all over the yard, tables flipped, fridges flipped, and eventually the suspect was arrested for assaulting Miss Bauer as well. As Your Honor noted, the distance between the one-stop shop and the victim's home was 187 feet. That's well within the 2,000-foot violation. So for all of those reasons, we would ask that Your Honor sustains the bond violation. Thank you.
Yeah,
I don't know, the primary evidence we heard in this matter were often statements from dispatch, hearsay that was not admissible for the truth of the matter in this matter. We do not have any testimony that 109 Fairfield is actually Miss Bauer's address. She did not testify today. She did not say where she lived. All we have is that an officer did see her walk back toward that place. I don't know if she was living there. The underlying case here, there was a situation that occurred at a friend's house of Mr. Carter and not her residence. The order itself does not say to stay away from 109 Fairview, Fernhill. It just states 2,000 feet from her residence. Without knowing where her residence is, without having actual evidence beyond hearsay statements from dispatch, I don't believe that they've shown that that they can prove that he was within 2,000 feet of it. When it comes to walking into the store, these situations will certainly occur where somebody on bond might walk into a Meijer. If they see the person, it is not a violation immediately. It is their duty to turn around and walk out. In this situation, Mr. Carter walked into the store. He was immediately stopped by the police. He had no opportunity to walk out. So I believe that based on the actual evidence that we heard here, that there's not sufficient evidence to prove a bond violation in this matter without any testimony from Ms. Bauer. So I would ask the court to find that there was no violation. Thank you.
Brief, Your Honor, just regarding where Ms. Bauer lived. I know we didn't have Ms. Bauer to testify. I, more than anyone, wanted her to be here and attempted to get her here. Regardless, Your Honor, I think it would be unreasonable to assume that the house that she called and stated was the house she was assaulted at was hers, and then walked back to with her baby barefoot after the officers made contact. Your Honor, there's more than a reasonable assumption there that this was her. So, thank you.
So you heard the testimony from Officer Jamil Jones, testified that on or about August 3rd, midnight, 12:08 in the morning, that he responded to the area at or near 109 Fernhill Court because a dispatch of an assault complaint with a individual victim named Kylie, last name Bauer, and he testified that during dispatch or after that initial dispatch, there was a secondary address that was provided, and it was an address of a corner store that was on Grand River in the not too far from the area of the original dispatch. Officer Jones stated that he responded to that store and he spoke personally with a clerk of the store. The clerk indicated that he was hiding the person who was the named victim of Kylie Bauer in the freezer with her baby. Officer testified that he found this individual in the freezer, that she had no shoes on, she had her baby. He testified he didn't initially make contact with the suspect, but that while he and his partner were continuing their investigations, the store clerk was looking through surveillance camera footage, and around that time, the suspect returned to the store and was pointed out to officers by the clerk. Officer Jones testified that the defendant was immediately detained, or the suspect was immediately detained, and the suspect was later identified in court today as the defendant, Marcel Carter. The officer was questioned about how close in proximity this store was to the address of the alleged victim. And that officer testified unequivocally that it was much less than 2,000 feet. And that's without telling us the address. But that testimony is that it was much less than 2,000 feet in distance. The officer also testified that he went back to the address of the alleged victim in the underlying matter and saw other evidence in that or at that address that would support and corroborate the allegation of an assault that she was retreating from when officers were dispatched to the secondary store. Officers testified that the Ring camera at the door of the residence had been ripped off the home, that there was an appearance of some struggle inside the house, tables flipped over, some appliances flipped over. I recognize we don't have to the person in the jail. I'm going to put you back in the waiting room until I finish this hearing so that I don't get feedback, okay? I recognize we didn't have the testimony of Ms. Bauer present today. However, the court can construe based off the testimony of the officer, which is that he reported to the address of the victim, and that this address was not too far from where the store was, and that the store was also the store in the address of where the defendant was located the store was not too far from where that address was either. The defendant's address, at least on this file, is an address on Glasgow, which would not render it reasonable for him to ironically walk into a store all the way on the other side of town where it just so happened that the alleged victim, Kylie Bauer, would be at about 12 o'clock in the morning, hiding in the freezer with her child with no shoes on. And so the court has heard more than enough circumstantial evidence to conclude that there was a violation of the no contact order. He was arraigned. Mr. Carter was arraigned by Magistrate Milmore on July 25th, and he was advised that he was not to be within 2,000 feet of wherever the alleged victim lives, works, or goes to school. If I had arraigned him, it would have been a little bit broader because I use the terminology, you're not to be within 2,000 feet of wherever she is. I don't care if she goes to school or work. If she goes to Burger King, you're not to be there. If she goes to Meijer, you're not to be there. I don't think that it was a coincidence that on August 3rd, that Mr. Carter walks into a corner store at almost 1 o'clock in the morning when the alleged victim is barefoot with a baby in a freezer. after police were dispatched in a response to an assault. And then when they report to her supposed or alleged address, cameras have been ripped off and there's evidence that would support the reasonable belief that a struggle of some sort took place at that residence. So with that being said, the court is satisfied beyond a reasonable doubt that there is or has been a violation, and that violation will be sustained. You can address the court before I post sentencing.
I'll leave it to the court's discretion, Your Honor. I have nothing from the people.
Your Honor, in this matter, Mr. Carter was arrested on August 3rd. He has now served 25 days in jail regarding this incident. I would ask the court to consider sentencing him to 25 days of time served, perhaps reinstating his bond, maybe adding a tether so that he can be monitored to make sure that any of these violations don't happen in the future.
I can appreciate the request for credit time served, but I have an allegation sustained that not only was he in violation of the no contact order, but it's more likely than not that that violation resulted also in some violent or harmful contact. The violation sentence is 93 days Ingham County Jail credit for 25 days. The bond will be amended to 5,000 cash surety with GPS tether and victim notification if possible. You're not to be within 2,000 feet of wherever the victim is. You're not to have contact directly or indirectly. That includes while you're in custody of the Ingham County Jail. Do you understand that? Yes, do you believe so?
Yeah, just.
What portions do you not understand?
The last part, I was just trying to figure it out.
The last part was you're not to have communication directly or indirectly with Kylie Bauer. So that would mean that you can't call, you can't talk to her, you can't write a letter or send a smoke signal, use Morse code, fly a kite or a blimp that would deliver a message. Nor can you have anybody else, a family member, friend, or use another inmate's number to do so to make contact with Ms. Bauer. Do you understand that now? Okay. So absolutely under no circumstances should you be in contact or communication or within 2,000 feet of wherever Kylie Bauer is. When you are released from custody, it is with GPS tether and on a 5,000 cash surety bond. Any additional matters for today's record?
Nothing further from the people. Thank you.
No, Your Honor.
You're all set. Jordan Brown, President Brown. Jordan Brown. Who represents Jordan Brown?
Jacob Raleigh. There's no one out in the hallway, and I don't believe there's Jordan Brown up here. I can check his notes about contracts.
Red. All right.
Is Mr. Chapman?
No.
No.
Chapman.
Oh, is Mr. Nance? Who's in the jail?
Troy Nance,
And then Mr. Blackman is here with Jocelyn Davies. On the record, in the matter of the people of the state of Michigan, or the matters of the people of the state of Michigan versus Jocelyn Davies, file number 24-01743, 01744, 00436. Council appearances, please.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Mr. Blackman? I think you're muted.
Fred Blackman on behalf of Miss Davies. She's also on Zoom.
Today's date and time that was scheduled for pre-trial on 2 dog at larges, and then I have sentencing and restitution on the file number 24-00436. Are we having a restitution hearing?
Your Honor, regarding the restitution amount, I reached out to the victim, Jason Rybar, yesterday to confirm the amount he was seeking. He was seeking $300 in restitution for what seemed to be some vet bills as a result of the dog at large. I spoke with Mr. Blackman. It's my understanding we have a stipulation to that $300 amount, so we won't be having it.
Okay, that's correct, Mr. Blackman?
It is. I talked with my client yesterday and she has agreed to pay $300 in restitution.
Okay, and how are we dealing with the other 2 dog at large files? Did we just reset these?
Your Honor, I've been provided proof of the fence being fixed that caused the 2 dog at large issues, so people would move to dismiss both the pre-trials. Files number 24-01743 and 24-01744.
Okay, motion to dismiss is granted on those 2 files, and then, let's see. As to dog at large, the sentence is a $75 private victim rights with $50 state minimum costs. It's gonna be $125 plus the $300 in restitution by stipulation. I do need a restitution form on that. And when is your client going to pay this?
Miss Davies, how long do you need to pay the total amount?
I can pay it today.
I'll note that she'll make payment today, and she'll make payment by going to the court website using her case number, or she can come up and make payment at the criminal traffic window, okay?
Thank
Yes,
you.
ma'am.
Thank you. Any additional matters for the record today?
Nothing further from the people. Thank you.
Nothing further from the defense, Your Honor. Thank you.
You're all set. Who's representing Troy Nance?
That's Mr. Lumpy. And he is on the whole talking to him really briefly. He's also trying to give Crano a call to see if they're near.
He's talking to who now?
David Raleigh is speaking with one of his clients out in the hallway, Mr. Williams, and he's also trying to call around to see if they're near.
Who's representing Cadence Blundell?
That is myself, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Cadence Blundell, file number 24-02054. Council, can I have your appearance?
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Cadence Blundell.
Can you hear us, Ms. Blundell?
Yes, ma'am.
Your Honor, I apologize if I may. I was unaware Ms. Blundell was on Zoom and I wasn't able to speak with her yesterday. May I have a brief couple of minutes to speak with her?
Yes, we can go off the record.
Thank you so much. And like, it just didn't help.
Was this person behind us waiting for a court date?
This is Mr. Castellano.
Who's representing him?
I am, Your Honor. I was appointed this morning.
On the record in the matter of the people of the state of Michigan versus Jamie Castellano, phone number 24-02286. Council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Warren Sutter on behalf of Mr. Castellano, who is approaching council bench now.
Okay, today was the date set for pretrial, but you indicated that you were recently appointed.
I was appointed this morning, Your Honor. However, I'm the one who caught this yesterday, so I was able to review discovery here. I've had a discussion with Mr. Markarian. However, I've been waiting this morning to have further conversation with him.
Was there an offer?
Yes, Your Honor, there was. Check my notes. I just sent it over this morning. After I found out Ms. Sutter was on the case, the offer is to plead to domestic violence with sobriety court through 55th if Mr. Castellano is interested and eligible.
Time to talk to your client about that.
I wanted to speak with Mr. Markarian about that because I'm not understanding the logic of the sobriety court from Mr. Castellano.
Sounds good.
Based on victim contact, Your Honor, that was something that the victim was interested in seeing.
The email I got said drug court, and that one confused me since I saw no reasons for it. At this stage, we'd be requesting the final pretrial.
September 17 a.m. Pretrial September 17th, 8 o'clock in the morning, in person at the court. Jury trial October 22nd. And jury trial October 22nd, 8 o'clock in the morning, in person at the court. Do you have any questions today, Mr. Castellano? Issue your notice to appear. Any additional matters for the record, counsel?
Nothing further for the people. Thank you.
Nothing further, Your Honor.
Thank you. You're all set. Let's see. We need to see if Mr. Raleigh needs to meet with Mr. Nance. Sam, are you waiting for a court date? Yes.
This is Ms. Scott. She is here for a pretrial. She's unrepresented right now.
She's requesting court appointment. Counsel? She
advised me she did. We have no application for her. So if she'd like to apply further today, I would grab that application from her. She has provided some documentation for this Mark Perry, so I don't know if this one's also.
It is a dog case, Your Honor. I don't know if you want me to talk to her first or.
It's a dog case. It's standard offer is for her to address the issue and they dismiss it. So, yep. People moving to dismiss that.
Yes, Your Honor.
And you're all set, ma'am.
Thank you.
You're welcome.
I'll give it back to you. Let me just take a photo of it real quick.
On the record in the matter of the people of the state of Michigan versus Troy Nance, file number 23-03436, council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Rowley on behalf of Mr. Nance.
Mr. Nance is present via Polycom from the Ingham County Jail. Today's the date that's scheduled for a pre-trial. There was previously an offer. It was for disorderly jostling. How are we proceeding on this?
Your Honor, my client is requesting final pre-trial dates in this case.
Article trial September 17th at 8. Jury trial October 29th at 8 a.m.
Final pre-trial, September 17th, 8 o'clock in the morning, in person at the court. Jury trial, October 29th, in person at the court at 8 o'clock in the morning. Do you have any questions to address with the court today, Mr. Nance?
No, just, they said I didn't appear in court in July. And the reason why I didn't appear in court because I was in custody and my bond was taken away. I want to ask the court to kind of get my PR bond reinstated. I got my paperwork and everything.
Your Honor, my understanding is that Mr. Nance was in custody in Charlotte on the June date that he did not appear in this court. It resulted in his bond being
He told the magistrate that he was in Petoskey and he didn't have transportation.
You mean?
You told the magistrate when you were arraigned that the reason why you didn't appear is because you moved to Petoskey and you didn't have transportation.
That was back another date, but on the date that on the 28th, I was in custody in Charlotte.
Well, you're supposed to be here on June 25th, so provide me evidence, counsel, that he was in
I have it
custody.
right here. I have an evidence right here, man.
I want your attorney to provide me evidence. I can't see through the computers.
I'll get that from you today, Troy, and we'll get that to you for.
If you can provide that, then I can amend the bond or reinstate the bond. So he'll get that to me today, okay?
So my bond be reinstated today once he gets this?
If he
His
can provide
paperwork?
me the evidence, then I can reinstate your bond.
Okay.
You're all set for now, though.
Just, Troy, when I see you later, make sure you bring that with you, okay?
All right. Yeah, because I'm trying to get out of here. I'm about to lose my place and everything because of
We'll
a
talk
mistake.
this afternoon, Troy. We'll talk. Just bring that paper with you when we talk, okay, in person.
Thank you.
Thank you.
Let's see. Who's representing Blundell? Is that correct? Who represents Blundell? Sutter? Okay. And then I think that's all I have for now. Let me see, is Dante Chapman is gonna be put on, or is he downstairs?
He's downstairs.
Oh, who represents him?
So, Lauren Sutter and I both represent him. She represents him on the probation file, representing misdemeanor.
Okay, and then misdemeanor is the one that's set for contempt hearing today,
That's correct.
and we have any hearing?
No, he intends to plead guilty to it.
Okay. Brought up. Have you seen Michael Williams?
He is here, Your Honor.
On the record in the matter of the people of the state of Michigan versus Michael Charles Williams, file number 24-00792, council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Rowley on behalf of Mr. Williams.
Okay, Mr. Williams, you have a pre-trial today. And this is for domestic violence. How are we proceeding?
Your Honor, it would be our request to set this matter for a final pretrial to allow time for a victim contact. I'm hoping that we could resolve this with a disorderly jostling, but I need to confirm that and prove that with the victim first. For the record, I did attempt to contact her yesterday. It was just unsuccessful, so.
Sounds good. Final pretrial September 24th. October 29th. Final pretrial will be September 24th, 8 o'clock in the morning, in person at the court. Jury trial October 29th, 8 o'clock in the morning, also in person at the court. Okay, sir?
Okay.
You have any questions?
No, Your Honor.
We're gonna get you your notice in just a moment. Any additional matters?
Nothing further from the people. Thank you.
No, Your Honor. Thank you.
You're all set.
thinking.
One of you all can send that back to me. This is Chapman.
Yes.
On the record in the matter of the people of the state of Michigan versus Deontay Chapman. File number is 24-01-767, 24-02009. Council Karen.
Morning, Your Honor. Case Mark Hearing appearing on behalf of the people.
Jacob Riley on behalf of Mr. Chapman. On cases 24-01767 SM and 24-02009 SM.
Today was the date and time set for a pretrial for the larceny matter. There's a show cause and a bond violation on the other matter. How we proceed on that?
Mr. Chapman will admit and plead guilty to the violation retrial release on the domestic violence.
Okay, that's for the allegation of jail calls, correct?
Your Honor, the allegation I received is violation of no contact order by hearing at the court with the alleged victim on that case.
That's the violation he's pleading guilty to. That's
Yes,
correct,
Your
sir. You want to plead guilty to that violation, sir?
Sure.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? If you can put your hand down. We ask the violation stated by your attorney, which is for appearing to the court with your like victim from another matter. You have the right to have a contested hearing. You have the right to be represented by your attorney at that hearing. Do you want to give up your right to a hearing on that matter?
No,
You don't want a hearing? Anybody threatening you to waive your hearing on that? Any promises being made to you if you plead guilty to the violation? Okay, as to the violation that you appear to the court with a protected party that there's a active no contact order in place for, how do you plead? A factual basis, counsel.
Thank you, Your Honor. Mr. Chapman, is it true that on July 6th of 2024, this court granted you a bond on the domestic violence case? With that bond, they created certain conditions. So it was one of those conditions that you were not to have direct or indirect contact with excessive commands. So is it true that you violated that order by well, certainly having contact with Ms. Hernandez and by appearing with her at the court for arraignment on another case? So,
Any questions from the prosecution on that?
People are satisfied with the factual basis, Your Honor.
Substantial factual basis, I'll accept your plea and find your plea be made freely, voluntarily, and intelligently. There were, at the last court, they released an allegation of jail calls, because that's noted on this file. What's going on with that?
I have not received any further information on that. I know that Mr. Pfeiffer mentioned that, but I haven't heard any follow-up on that.
Yes, Your Honor, I haven't heard specifically. I did communicate with Mr. Pfeiffer about these files yesterday. He didn't mention specifically any updates on the jail calls. My understanding is that they're still awaiting a pretrial conference date for circuit court, and that all of this is supposed to be resolved as a global resolution plan.
Okay, and so the larceny, that's also supposed to be final, a global resolution on that one as well.
Yes, Your Honor, we would ask for an adjournment on that. I asked for a specific date for pretrial conference and circuit court, but it doesn't appear they even have one yet. So we might need a month or so on
Okay, let me get you a date for the larceny. I'm sorry, you said 30 days on the larceny and actually the DB underlying. We're setting that as well, the DB for global, or
Yes, Your Honor, I think that'd be prudent. I'll let Mr. Pfeiffer know when I get back to the office as well.
October 1st at 10.
October 1st at 10 a.m. For the two trials on those. I suppose we'll have to address the issue of the allegations of the jail call. It's not turned anything over to the prosecution yet. But I've already revoked his privileges, so something needs to be turned over.
I'll send Mr. Pfeiffer an email right now about it. I'll see if I can get a response here shortly. He's usually pretty good about responding.
And we can address further and sentencing for the violation that we just put to. Mr. Rowley.
Certainly, Mr. Chapman, and then we violated the court's orders regarding any contact with the alleged victim on this case. Certainly, consequences are warranted. I would remind the court that it's just stated, Mr. Chapman is a felony case that is holding him in custody. We don't have a court date yet on that case. I expect we'll have one, or at least know of one prior to the next trial conference on the 1st. My request would be for a jail sentence concurrent with his current incarceration on.
Time served on that violation. And we're waiting for a court date on the matter that's before the circuit court. I believe we set the other matters out until October 1st on that. Any other matters on these two files?
Nothing further from the people. Thank you.
No, Your Honor, thank you.
You're all set on those. And then
It's just.
Okay, everybody on Blundell or Blundell?
Yes, sir. It should be a plea.
Okay, on the record in the matter of the people of the state of Michigan versus Cadence Blundell, file number is 24-02054 SD. May I have your appearance, please, counsel?
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Blundell, who joins us via Zoom.
Okay, Ms. Blundell, can you hear us?
Yes, ma'am.
Okay, today's date and the time that's scheduled for a pre-trial, and this is for operating with a blood alcohol content of 0.17 or higher. And there's been an offer. It says the people are offering for you, Ms. Blundell, to plead guilty to add count 2 of operating while intoxicated, MCL 257.6251, 93-day misdemeanor and or $100 to $500 in fines and or 360 hours of community service. So you want to plead guilty to the amended charge, ma'am?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Okay, in order for you to plead guilty and accept this amended charge, you would need to understand your rights and then have to give those rights up, okay?
Yes, ma'am.
You have the right to the presumption of innocence, so that means that you're innocent until the people can prove you guilty. So you have the right to maintain that innocence and require the people prove each element of the charge being brought against you beyond a reasonable doubt. Do you understand that right?
Yes, ma'am.
You have the right to appear at your trial and confront in court and cross-examine any of the witnesses that the prosecution intends to call against you. You have the right to have witnesses subpoenaed on your own behalf to testify or to present evidence at trial that you believe would show a defense to the charge being brought against you. You have the right to be silent and not have silence be used against you, or you can waive your silence and testify on your own behalf at your trial if you like. You understand those rights?
Yes, ma'am.
And are you willing to give each of those rights up today?
Yes, ma'am.
Is anybody threatening you to get you to do that?
No, ma'am.
Any promises being made to you in exchange for you entering a guilty plea to the amended charge? Any promises being made to get you to plead guilty today?
No. No, ma'am. Just the plea.
Who's talking to you?
My mom.
Okay, I'll reset this for in person. She's getting somebody over there telling what to say. You gotta appear in person to accept the plea.
Your Honor, if I may repeat what her mother said, I think she was.
I don't care what her mother said. She doesn't get to have somebody on the side talking to her while she's accepting the plea, getting advice. So she can appear in person. I can't ascertain. Her mom could have a gun to her head off this camera for all I know. So I don't care what she said. She's got to appear in person.
September 3rd at 1:30.
I repeat that date.
September 3rd at 1:30.
September 3rd at 11:30. At 1:30 in person at the court for a plea.
1:30.
Do you have any questions, Ms. Blundell?
No, ma'am.
Okay, any additional matters for the record, counsel?
Your Honor, just to state for the record, I believe that offer included HYTA status.
That's noted here on here.
Nothing further from the people. Thank you.
Nothing further, Your Honor.
Thank you. You're all set, ma'am. Okay, do we have anybody else now? Is that to everybody?
I don't believe so, Your Honor.
I issued a bench warrant for Brown. Let's see what's going on here. You want to check for something for me, or did I miss something?
I reset it.
Oh, okay. And these I think are all afternoons.
Yeah.